Hi there guys, Alex Woods here reporting from the Middle Temple, Inns of Court in central London, and I'm posting on this rather important 10 days in the life of Redwood Legal, in the life of me as a solicitor, in the life of my business project, bringing claims on behalf of consumers against banks for the mis-selling of financial products. And what I'm majoring on today is, of course, the claims that we've been running in respect of offers that have previously been made and money that's been paid to consumers, in some cases over a year ago, which we say are inadequate. We say these PPI refunds, handouts that have been made by banks are inadequate, and we say that they're inadequate because they only, in certain cases, not all, but in the cases that we're running, they only include for simple 8% interest and not compound. And we say compound is appropriate where the consumer had high costs of borrowing, a credit card no less, with the same lender who mis-sold the PPI on their loan. They were struggling under high borrowing costs on their credit cards, and therefore simple 8% is not appropriate. So I'm going to focus in this posting on 4 key criteria or considerations that consumers, and this is also aimed at lawyers out there, should have in mind before they embark upon the somewhat time-consuming and potentially costly exercise of bringing a claim against a financial institution because you don't think that they've paid you enough. Right, so the first thing to say is, before I get into the meat of these 4 points, is that over the last 10 days we have had, it's probably been the busiest period in my career actually. I've had 4 trials. I've just come out of a telephone hearing, which we won, fortunately, in 1 Essex Court here, the chambers that I regularly use. But I'm not going to talk about that. I'm going to talk about the trials and the hearings that we've had over the past 10 days. And basically we've had 2 key strikeout applications in 2 of our, we're calling them true loss or additional refund claims. And I'm also going to touch on a couple of claims that we've been forced to settle. And I'm also going to mention a really rather interesting claim that took place in Milton Keynes County Court last week, a full trial. So we've had trials and hearings coming out of our ears over the past 10 days. So, keep your ears peeled. Don't tune into another internet channel because it's all going down here on Redwood Legal, cartoonbankers.com. I'll allude to these cases as I go through these key 4 points. So, the first thing to say is that it's really important that you can demonstrate to your bank and then to a court, if your bank doesn't listen to your complaint, that if you'd had that money that the bank has deprived you of, respect of the sums you've been paying each month to the loan repayment, that part of the monthly repayment in respect of the PPI loan, it's important for you to demonstrate that had you got that money in your hands at that time, you would have used that money to reduce other higher costs of borrowing. And we say in these cases invariably that, let's say a consumer might have had £50 or £100 that he was paying each month to the PPI loan. He could have used that to reduce his credit card. And now everybody in this day and age uses credit cards, and people who borrow money from banks and who have loans often use credit cards more than others. So it's important that you demonstrate that you would have actually have used that money. So you want to be able to show to the bank or the court that you were struggling in respect of your debts, and that had you got the money, you would have used it to reduce the credit card balance, or an overdraft on a current account was also earning the bank compound interest. Don't forget that the bank is actually giving you borrowing facilities, one borrowing facility on a fixed term loan and another borrowing facility in respect of your credit card, and they're charging you high levels of compound interest on your credit card, but they're only giving you back your PPI refund on a simple, not compound, 8% and not 25% interest basis. So anyway, that's the first thing to note. Now, that was a consideration in one of these 4 cases, not the ones that went to trial, but ones that we had to settle against Barclays. And I felt I had to settle because I had the consumer in my offices taking a witness statement from him, and ultimately he didn't say that had he had the money he would have used it to reduce other debts, other borrowings. And he especially didn't say that he would specifically use the money to reduce the credit card that he had with the same bank. So that's a case that we had to settle and take a hit on. By the way, no cost to the client. These cases are being largely, if not entirely, funded by Redwood Legal, and also most of them have been on the small claims track. Some of them are on the small claims track, such that even if we were to win, we wouldn't get our legal bill paid by the other side. So it's something of an investment for us as a business, and something of a speculative enterprise, I suppose you'd say. So that's the first thing. The second thing to note is that this is really something that it's an X factor, and that is that a judge might conclude that he's not comfortable with you coming back for a second bite at the cherry, Oliver Twist, coming back to the head table and asking for more. Okay, and that's something of an irrational point. One district judge, perhaps the older judges who don't so much like the consumer credit regime, but that's probably an ageist statement. But some judges are perhaps, rather than age, who might be a little bit fixed in their ways, might not like the idea of you coming back for an additional refund where the bank has already sent you out has already settled your address, sometimes, as I say, as long as a year ago. Now this is relevant in the case. This is relevant in the case where we had a 2.5 strikeout application on Wednesday, because the judge, in passing, wouldn't form part of our judgment, but she kind of couldn't help but mention it, said that, you know what, even though the offer that Lloyd's made to your client didn't say this is in full and final settlement of your claim, even though it said that, even though it didn't say that, sorry, I feel there's been a valid compromise, it's the legal word, a valid compromise of your claim, and therefore the legal principle of res judicata or valid compromise or merger, these are all clever terms, technical terms for not being allowed to have 2 bites of the cherry where this issue has already been a compromise or has already been reached. So even though it didn't have full and final settlement in the letter, I'm still not going to, take your claim seriously. So that's something that a district judge, for example, if you were to find yourself in court, they may take that view. So, and the flip side of that, actually, and I now allude to another case that I settled, and I settled this case, and I settled it on a drop hands basis, so we both walked away. Both parties walked away. The consumer got nothing, the bank got nothing. Each party bore their own legal costs. That's what drop hands means. In that case, it transpired quite late in the day. We had disclosure of the fact that my client that the bank had written off the loans many years previously, possibly had sold them to another company, debt purchaser, and also had charged off, written off a reasonably substantial overdraft on a current account. And so for all these sorts of reasons, they had almost had a counterclaim against our claim for additional compound interest that in effect meant that it was pointless expending money on lawyers and court fees, etc., taking this thing to trial, when at the end of the day, my client was going to get pennies out of the deal if they won, the other side, likewise. So that's that case we settled for those reasons. But the reason I mention it, because in that case against Barclays, there was a full and final settlement. But although that full and final settlement term appeared in the letter, the fact is that we thought that because the banks had been quite heavy-handed in dealing with the complaint, because they'd actually told our client this is the sum of money that you're going to get, because they actually unilaterally set it off against the debt the client had on loan, because they just sent out a cheque, because the client was in financial difficulties, didn't really understand compound interest as opposed to simple interest, kind of all those reasons, I thought that we had a reasonably strong case to say, even where full and final settlement had been stated by the banks and the consumer had accepted that, you could reopen that agreement and have two bites of the cherry. So, as I say, I give those two cases as examples of the fact that there are vagaries involved, and that where you've already had the matter settled, it might be that a judge may find against you. The key here is if you feel you have been ripped off, if you feel you've been shortchanged, if you feel there's some lack of fairness, equity, lack of justice in the original arrangement and the original offer. So that's the second point to take away from these hearings that we've had this week. I think probably the third key area is probably the third key area is that, and this is a positive you can take away from the hearings that we've had over the past week. I should explain, in one case our claim was struck out, in the other case the claim continues. One thing to remember generally about these types of cases is that if you can bring the unfair relationships test as a head of claim against a bank, which is a bit of legislation under the Consumer Credit Act, if you can rely on an unfair relationships test head of claim, then that gives you a great advantage. Now, in not all cases, for reasons to do with Limitations Act, fulfilling the requirements, the loan completed at a certain time, that the loan commenced at a certain time, the various criteria, but basically an unfair relationships test claim, the loan must have completed after April 2008. Slightly more complicated than that. That's a good yardstick. And if your loan is still current, then you will probably be able to avail yourself of the unfair relationships test. Now, this is a bit of legislation that's really quite radical, and it really is something that the banks are afraid of. And I'm just going to touch on another trial we had on Friday, in which we felt we had a reasonably weak case, but it was on the small claims track, and so we felt that even if we lost, we wouldn't have to pay the other side's fees, and we felt strongly about the case. We felt strongly about the client with whom we travelled a long road with, and she was really pissed off about having been sold a PPI product on her credit card by MBNA, and so we decided to go to trial and reject a low offer of settlement from the other side. And it was really surprising, because she simply stated again and again and again in open court, in cross-examination, I didn't want it. You stuck it on, I didn't want it. I didn't want it. Now, typically, before the Unfair Relationships Test Consumer Credit Act 1974, as amended, had been invented, people had to rely on things like breach of contract or misrepresentation or breach of statutory duty. These are like the gateways through which, I'm afraid, you have to go through in order to bring a case in the courts and get it in front of the judge. You have to plead the right gateway to go through. Now, the judge at the beginning of that trial said, the first thing he said was, my God, I was around when the Consumer Credit was enacted, and I felt it was a big mistake that Parliament ever then amended the Consumer Credit Act and created this thing called the Unfair Relationships Test. He was a slightly older judge. It was quite funny to see him express his views in that way when he was meant to be impartial. But interestingly, our barrister did an excellent job in his first trial. And by the end of the trial, 4 hour trial, the judge was actually saying, hang on, there's something in this. Because the Unfair Relationships Test puts the burden on the lender to prove, if you make an allegation of unfairness, such as a mis-selling of a PPI product, to prove that they acted fairly. And in the case of this MBNA credit card, even though there were strong arguments to say the client should have seen the PPI on their credit card, kind of acquiesced to it, left it on there for years, hadn't mitigated their loss by cancelling it earlier, the simple fact of it was that the client said she didn't want it and it was stuck on without her permission. So judgment has been reserved, which means the judge is going to hand down judgment in a couple of weeks' time, so I can't give you the results of that case. But it's certainly given MBNA, and they turn up in force at the trial, by the way, people from the office, not just their lawyers, it's given them a bit of a scare, I dare say, and I'm rather glad that we run that case, even though it's costing the firm money. But the point that I make really is that this is, even where your lawyers may be telling you that you haven't got a case because you can't get yourself through one of these gateways, these legal gateways, if you really feel strongly that you've been wronged, shortchanged, ripped off, that you've been given some money and it's a derisory offer to make you go away, the Unfair Relationships Test is a powerful piece of legislation, basically, and the direction, long term, the way the wind is blowing is in support of the consumer and the protection of the consumer. So I mentioned four things to take away from the trials and the hearings that we've had over the past 10 days. I mentioned the fact that you need to demonstrate causation, that the bank contributed to your loss, that you would have used that money to reduce higher borrowings on typically a credit card. I've also mentioned that full and final settlement is tricky. You've got to be careful about the two bites of the cherry argument. It can cut both ways, and that there may have been a valid compromise of the claim. And of course I've also mentioned that one of the that the Unfair Relationships Test is a bit of legislation that consumers really can and should try and rely on, and it's something that the banks are very afraid of indeed, I would say. And the fourth thing I would say is that you've got to carefully lay out the facts behind your claim. You've got to actually properly, the technical word is, particularize your claim. Now that touches on the big issue really, was that obviously in these cases we had an admission from the banks that in some cases that the PPI was unsuitable for the client's needs. Sometimes the letters from the bank said this is a goodwill gesture, but along with the cheque that they sent the consumer, they invariably mentioned the fact that implied that they had missold the PPI. So we didn't think that this would be too insurmountable a hurdle, and that the judge would take a view and accept that as admissible evidence, and therefore we wouldn't have to particularize our liability. In short, the fourth point is that you do have to prove your claim afresh. You kind of do have to start from scratch and prove all over again that you were missold the PPI. Even though you're just bringing a claim about inadequate quantum, you can't rely on the bank's payout admission when it comes to court. You can use it in evidence, and it will be good evidence that the bank did missell this product, but it won't get you across the finishing line. So there it is, as the rain now starts to fall on a rather muggy Friday afternoon, September the 19th. I shall close this video bulletin. But do stay tuned, because we have a few more of these cases, a few more of these hearings coming up in the autumn. So I'll post, if not in 2 weeks, perhaps in a month's time. Okay, that's all for now, and please stay tuned in with cartoonbankers.com.